Senator Gaddy, Senate Bill 78.
Thank you, Mr. Chairman, members of the committee. My name is Senator Ryan Gaddy, and I'm from Bossier Parish. I represent Bossier, Claiborne, Webster, and Bienville. And Senate Bill 78 addresses an issue that has come up over the years with our medical malpractice cap. With broad strokes, I just want to give some background of the medical malpractice cap. In the 1970s, there was a movement across the United States to cap medical damages, because we have surgery is a dangerous thing. The things hospitals do are dangerous items. So we came up with a system where the doctors were afraid that they would lose their personal assets if the claim was too high, and the court system really wanted to look at things in a different manner. So they cobbled together a compromise through a lot of hard work of lawyers and doctors and this legislative body. And they decided that it was very important to cap medical damages. What most people don't know in our state is that cap has not been changed since the 1970s, before most of us were born. So at that time, they said, you object to that, Senator Martini? Well, there's kids here today, so I did an average of the group, and those guys. No. Well, it depends on how you're going to vote before you recuse yourself. All right. So in the 1970s, they cobbled together this compromise that said, we agree ahead of time that no matter how catastrophic the injury is, that a family can only recover $500,000 plus medical bills. Well, as medical technology got better and better, we're finding that when people get hurt with severe brain injuries, they survive. And they survive for a long time. And so when we look at this special situation, what we find is that many people don't know that this bill, the Medical Malpractice Act, actually created two classes of people, and they treat them totally different. And the Supreme Court has said recently, that's okay. So you have these two classes of people. The first class is the person, let's just say they go to the doctor, and he doesn't ground the pad good for their surgery, so it burns a hole in their leg. Okay? And they did a little skin graft, and it's a horrible injury, it's painful, but it's worth less than $500,000. Okay? Well, they're fully compensated. Let's say they go through the panel process, they do all that they can, and someone determines this case is worth $125,000. Well, that's well under the cap, so they're fully compensated for their harms and losses. And you creep up more and more up to the cap, so if somebody gets a $490,000 verdict, they're fully compensated, 100%, whatever that injury is or that claim is. It's when you start to get over the cap that we start to see a great injustice. And one of the greatest injustices we see above the cap is we've had cases in Louisiana where a jury of their peers hears the case, and they feel sorry for the doctor for making the mistake. They feel sorry for the family for the long-time, lifetime injury, and the jury awards maybe $4 or $5 or $6 million for a brain-injured child or an adult. Well, in that situation, procedurally, looking back at the amendments to the Act, what has to happen if you're the judge, when the jury says, this is horrible, we want to give the family $3 million to cover their pain and suffering. And we want to give them unlimited medical, but we want to give them the pain and suffering that's equivalent with a fair trade value of the harms and losses they're suffering. What has to happen at that point is the judge thanks the jury, he lets them leave, and the family's still sitting there, the doctor's still sitting there, and the judge says, I have to order the damages of $3 million awarded by your peers. I have to reduce that to the capped amount of $500,000. That is the practical effect of the theory of medical malpractice reform. So once again, the courts have already said you can create two classes. That's completely fine. But what the Supreme Court recently said, and I was going to read the whole case into the record, but I'm just going to tell you some blurbs out of it to save time, is the Supreme Court said the legislature decided this. The legislature can do a constitutional balancing test. The legislature can balance the citizens' rights with the medical profession's rights. And they said since the balancing test happened, since it's a legislative act, it is not unconstitutional to have a cap. Well, the next logical step in that evolution is that we as legislators would look out into society and we would say, is this cap still enough? Is it? Is it something that we want to hang our hat on and call it justice now that medicine has advanced? Is it something that we want to go back to our constituents when they call us, after they hear about this bill and say, hey, I'm sorry, but we agreed way ahead of time in 1970 that your child's brain injury was only worth $500,000. And that's something that this bill directly deals with. So there's been a lot of scare tactics. There's been a lot of emails. In fact, some of the people that were coming to testify received letters reminding them they had a gag order on their settlement, and so they didn't make the drive. So what this bill does is it basically says this: based on the Supreme Court's recent finding that we as legislators get to dictate the level of safety in our community by the level of the cap. This says we're only going to carve out a specific low frequency, the most unjust of all of these injuries, which is someone under 18 who, because of medical negligence, suffers a moderate or severe brain injury. Not a mild brain injury, because as y'all know, mild brain injuries are defined as losing consciousness. This is not what this bill does. This bill directly only affects a diagnosis of moderate or severe brain injuries. And at this time, I think it's proper that I offer my amendment 1760. I'd ask the staff to pass that out, because I think now's the proper time to talk about how narrow the class of people who would be able to even partake in this bill. And while they're passing that out, I'll just explain it. I mean, we wanted this to be a very narrow exception that creates a third class of recovery under the Medical Malpractice Act. And based on what I've been told, there's only been 4 of these a year. That's what I've been told. And I know they'll testify today after filling out a red or a green card, and we can ask them if it's a higher frequency than that per year. But the yearly average I've been told is 4 catastrophic child brain injuries per year. So we're not talking about a huge class. So what we've done is we have inserted on page 2 that this only pertains to catastrophic brain injuries. Okay? And then we went to give a definition that is conducive to the legal definition of a brain injury, which means any moderate or severe traumatic brain injury. Now, there's 3 classes of brain injuries that are acknowledged by neuropsychologists in their writings, and there's three levels that are acknowledged by the courts: mild, moderate, and severe. Without getting into too much of those definitions, mild is they use the Glasgow-Coma scale. They could say you lost consciousness for 30 seconds, 15 minutes, and that would make you a candidate for a mild traumatic brain injury. That's not what this bill is about. This bill goes further to say it must be moderate or severe traumatic injury that causes a child to lose partial or total use of one limb, become a paraplegic or a quadriplegic. So that is the orthopedic component of the neurological injury. So if a child has a basal ganglia injury from a hypoxic ischemic event, whether they're having rotator cuff surgery and were positioned wrong, or whether it's a birth injury, well, that child, and we're not talking about somebody who loses consciousness for 5 minutes. We're talking about someone who has lesions in the brain. It's an objective finding. You can put their MRI on the table in front of any neuropsychologist, and they will say, that's a lesion. That lesion is not something you walk around with and play baseball with. That lesion is the reason why they can't move the right arm. Okay? And so So let's go back to the definition of the amendment on line 9. Catastrophic brain injury means any moderate or severe traumatic brain injury that causes a child to lose partial or total use of one limb or become a paraplegic, which is they can't use, two of their limbs, or a quadriplegic, meaning that their brain injury is so bad they have lost the function of all motor skills. They're basically wheelchair bound. And child means a fetus in utero, all the way up to somebody who hasn't had their, who's under the age of 18. And we all know that's defined by the courts as you haven't reached your 18th birthday yet. So if they're 18 years in one day, this doesn't apply to them. We make other similar age classes, for instance, first-degree murder. If you're under 12, or I think if you're over 65 and you're the victim of murder, the defendant is charged with first-degree murder just because of the age of the victim. So throughout our legislative history and our intent, we always protect children. Children are our destiny, they're our hope, they're our future, and they need to be protected because they're the most defenseless when it comes to this. So here's where the objection comes in. I don't think anybody agrees that if well, let's talk about the procedure first. Currently, the procedure under the law, now that we've got the class. Yes.
I don't want to interrupt you, Senator Gaddy, but would you like to go ahead and adopt the amendments, and then we can...
Proper at this time, yes, sir.
Are there any objection to the amendments? No objection, the amendments are adopted.
Thank you. So now we have the class of people properly defined that can recover. Now I want to tell you a little bit about medical malpractice procedure before we talk about the narrow gate these people have to go through procedurally to even recover the excess cap. What you hear today is deferred maintenance. We talked about that in this room yesterday. It's the drilling and the fixing of broken down stuff. So bear with us. That's the sound of progress. So let's talk about the procedure under the law currently. Just with broad strokes, I don't want to get into the weeds on this. If someone is suspicious that the injury they have comes from medical malpractice, they have to file a letter with the patient's compensation fund. A board process is put in place where a panel of 3 doctors that are chosen by each party, they look at the medical records and they talk with each other and they get to vote. Panels can vote 1 to 2 for the patient, 1 to 2 for the doctor, or unanimous that the doctor was okay, or unanimous that the patient has a claim and the doctor fell below the standard of care. So that panel of doctors is a very important step in the process. So,
They're in the process of getting that noise to stop. I apologize.
okay. I suspect that'll be just one of the few interruptions to my my goal here today. So we talk about the procedure. You have to go before the panel, and if you get a unanimous panel against the patient or a unanimous panel for the doctor, then that kind of stops the process. A lot of times the lawyers will tell the patient, look, you've had 3 doctors already say this isn't malpractice, you just need to dismiss your case. However, there are situations, very rare, where the panel rules in favor of the plaintiff. Then the plaintiff has the right to file a lawsuit.
Do you want to pause for a second while they
Sure.
get that taken care of? It's important, and we need to make sure we hear everything.
Sure. I have some jokes I can tell while we're waiting on that.
That'd be good.
All right. A lot of people ask why we run for the Senate. They say, why don't you run for the House? And I told my oldest daughter, who's 16, I said, look, the Senate is like Starbucks. We walk in there, we drink our coffee, we look at our laptop, we may or may not have to talk to people. It's really nice. I said, the House is like when you go with your mama to Walmart on Black Friday. I said, your buddy will run you over for $50. I said, so that is why Daddy ran for the Senate and not the House. But I love, if any House members are listening, that was a joke. No allegory or metaphors.
I think we're good now. It sounds
Right.
like it's stopped.
Right. So let's talk about that procedure. First of all, the patient has to know that something has happened. They have to follow the procedure of the Medical Malpractice Act. One of the biggest points in that procedure is that you go through the panel stage, which is a very great procedure. It's awesome because you get 3 doctors to take a fresh look at the medical records, and they say, either this was above the standard of care, it was at the standard of care, or it was below the standard of care. And then they have to say whether or not the injury was caused by the doctor. And so they go through that process, and they put a lot of time and effort into it, and it's a good process. And then Patient has a right, no matter how the panel turns out, to file suit, go to trial, and go before a jury of their peers and have their case heard. That was supposed to be a very efficient process that would take less time. It actually takes just as much time as a regular lawsuit in most cases to go through the process. So let's talk about what this bill does. So we've talked about the class of people that would qualify, okay? Those are children under the age of 18, in utero to 18 years old, who have suffered a catastrophic brain injury. And catastrophic brain injury is moderate to severe, with the loss of partial use of one limb, paraplegia, quadriplegia. So that person is sitting there. And this is what they have to do next. The panel of doctors has to be unanimous for the patient. Now that may seem insignificant to the public, but what I have heard from talking to folks that do a lot of this work is that is a rarity. It's a rarity because the doctor who may or may not have committed the malpractice gets to select one of the members of the panel himself. And so he's selecting somebody for the panel. And that means that person even said, man, this was not just below the standard, but also caused the damage. So what this bill says is you either have to have a unanimous panel, or if it goes to jury trial, which 90% or more of these trials never see the jury because it's too emotional for the family, quite honestly. Most lawyers will not drag their clients through a trial like this because it opens up wounds that have had stitches and they've opened up and the stitches break and it gets infected and it's an emotional wound. And 2 or 3, 4 years down the road, most people just say, I'm emotionally bankrupt. Take whatever offers there. Now you have some rare people that want to be advocates who go to trial and take cases to the state Supreme Court. So here's what has to happen. You either got to get a unanimous jury, a unanimous panel, or a unanimous jury. Now I don't want there to be any confusion. It's one or the other. Okay? But I can guarantee you if somebody gets a 3-0 panel against them as a patient, they're not going to take that to jury trial most times. You see? So we have a narrow definition that we have to balance based on what the Supreme Court has told us. A class of people, do we think our children who suffer quadriplegia, paraplegia, loss of a use of a limb from a unanimous panel, in a unanimous panel situation, do we think they deserve more than $500,000? That's what the decision you have to make today. You have to agree ahead of time the value of a child's brain. Now, National Geographic, I love their so the camera can see it. It's called Your Brain. And they dedicate an entire issue into what your brain does. Now, this is a lot easier to read than all the neurology journals I've read and the neurosurgery books, and even my high school biology book could have put some of these pictures in there and made it more interesting. But they laid out everything your brain does. I mean, when you ask a child, what does your brain do? Some kids will say it helps me smell, it helps me see, it helps me remember grandma, it helps me remember things. Other kids will say, well, that's how I can throw a baseball. Dad says I have good hand-eye coordination, and all those circuits go through my brain. But a lot of people, when you get older and you start to be around people whose brain is failing, you start to realize how precious the moments were that you had an intact, functional brain. So the brain injury is one of the most devastating catastrophic injuries because typically the person doesn't know they have the brain injury. They don't know it. They don't know they have the brain injury. The brain limits so many activities that we do that we take for granted. Walking, talking, throwing a baseball, playing softball, running, eating, calling out senators' names when they're not paying attention, Senator Milkovich. You know what I'm talking about? There's things that our brain does, and when you really get into studying the brain like I have, because, my daughter is a spastic quadriplegic from a situation that was a unanimous panel, you start to say, is there any help out there? Is there any stem cell research? I've talked with doctors from all over the country, and I said, I'll be there tomorrow with my child. And they say, Ryan, we've looked at the MRI. Even if we severed her spine at her neck like we do with severe cases, it's in her brain. It's not in her bones. Her bones are shattering around her hip because of her seizures. So even if we severed her spine, which is the most outlandish rare case surgery, she would receive no benefit from that because her pain is in her brain. Now sit back and think about that just for a second. No hope. We're not talking about people that say, I used to could move my arm like this and now I can't. We're not talking about those kind of medical malpractice cases. And he just moved his arm. He's not telling the truth. We're talking about objective, catastrophic injuries that currently under the cap is a complete injustice. So we have Senate Bill 78. It doesn't change the process. What it says is if you have a child under the age of 18 who has been severely, catastrophically injured with a brain injury, and guys, I'm going to tell you this just to be straightforward, this doesn't include spine injuries, this doesn't include decubitus ulcers, this doesn't include mama went to the hospital, told them she was allergic to morphine, and during surgery they gave her morphine and she stopped breathing and she's got a hypoxic ischemic event and she's got a brain injury. Doesn't cover those. All right? Because what we see in older people is if they suffer a brain injury because their brain is already myelinated and there's already connections and the corpus callosum is intact, the midline of the brain, that we can send those folks to a brain rehab center and they can relearn a lot because they can make new connections. But when it's a child, there's no connections there. They haven't reached those milestones yet where their brain has myelinated. So there's nothing you can do except love them, care for them, and consider them the blessing they are. You see? So what Senate Bill 78 does is it says basically two things. It changes the process for a small group of people, and then it raises the cap from $500,000 to $5 million. You may say, well, that's a drastic increase. How did you come up with that number? Times 10. That's all I did. I just said, this is 10 times worse. 10 times worse, and it's a rare thing. Now, you're going to hear a lot of arguments about this is going to cost people more money, and then healthcare costs are going to shoot through the roof. But you know what we find in states without a cap? It doesn't really make a big difference. In states without caps, doctors sometimes can't get, they want to go practice in a state without a cap, and they can't. And then they say, well, why can't I practice in your state? So well, we don't have a cap. Everything you do could affect the assets of our hospital. Think about that. Now, in our state, we have a $500,000 cap. So there's a lot of guys that compete with our excellent doctors who are board certified. Or like this old cardiologist that I know, he's not board certified, but if anything happens to anybody in Shreveport Bossier, they want to be on his table. All right, God has just blessed him with the ability to open your chest and fix it and sew you back up and you're out playing golf in 2 weeks, When you have a state that has a cap, we have unintended consequences of marginal practitioners competing with the best of the best doctors we have. Now, I don't say that to offend any doctors at all. What I'm saying is we have the best of the best in Louisiana. They could practice in a state without a cap. They practice here because they love Louisiana. I've talked to many of them about this bill who say we like this bill. Because what they say is I'm tired of competing in my market with people who are marginal practitioners and fixing their mistakes. Now, they can't be here today because, that would be a really tough thing for them to say in front of the people that are sitting behind me. So, once again, just to clarify the record, this is for a small group of people who have the worst kind of injury, and they have to meet a procedural hurdle that most cases will never meet. So I just ask for consideration from this committee, and I would appreciate any questions.
There is a question from Senator Martini first.
Thank you, Mr. Chairman. And I wasn't here in 1970 when they enacted the cap, but I was born. My question is, and I thought a technical amendment on your brain injury, catastrophic brain injury definition. Obviously, it has to be a severe or moderate severe traumatic injury to the brain. It would seem like under this definition, it would seem like any injury that caused partial use of a limb. I mean, I hurt myself skiing, and I have 3 numb fingers on my left hand. I guess that's a partial. And I don't know if that cleans that up or not. But that's not my. The big problem that we get, that I've gotten feedback from doctors claiming that the malpractice insurance premiums are going to go sky high, and while you appear to be limiting this to a very small segment of claims, it would appear to me that there's a vast number of physicians who could possibly inflict this type of injury that would be subject to, and you pick 10 times the cap. I don't know what the does that mean that the malpractice premium is going to go up 10 times? Because obviously in 1970, when they were considering this, I would think one of the considerations was that doctors were not going to want to subject themselves to a just an unlimited amount of damages on the thing, and might choose to practice otherwise. So, do you anticipate, if were we to pass this legislation, that it would affect the entire medical society, or or just a very limited number of? I mean, I understand somebody that does pediatric brain surgery, they would be very concerned with that.
Correct.
But an orthopedic, somebody, or a neurosurgeon. It would apply to all neurosurgeons.
Well, let me kind of address those. If it is that you said there's a vast number of situations where this could be inflicted. I mean, and that is why we legislate, because if it's a loss that can be spread among a large number of people, we need to have a rule that dictates the value of that claim, especially after the Supreme Court's ruling. As far as insurance going up and down, I don't think we have any control over that. I mean, over the years here, we passed legislation that was promised an outcome, and it just didn't happen. Hey, if you pass gambling, we'll have the best schools in the South. That didn't work out. If you do this, then this will happen. If you pass tort reform under Foster, then businesses will come here in droves. I mean, I
voted on all that stuff.
Well, I'm just trying to relate. So we have these situations where I'm not going to sit here on the table and say, you know what, this is going to make rates go down because marginal practitioners will have to leave the state. The hospitals will no longer give them surgical privileges because they have too many claims against them with babies. I could say that as a counter to insurance going up.
Yeah, but those marginal practitioners may not be doing stuff that would inflict this type of injury, but the general scope of their practice, I think, would cause their insurance company to rate them in a group that would possibly be subjected to the higher premiums. And I'm not saying the cap shouldn't be raised. I agree with you. If it was set in 1970, even if with a cost of living thing, it probably should have been raised. That's not my point.
But here's the thing: we're not trying to raise the cap for everybody that suffers from a catastrophic brain injury. This is only children.
No, and I agree that, and don't get me wrong, I'm not unsympathetic to your cause, but my experience in this body is that this year we're doing that, and I'm sure there are other people in other situations that believe they have just as serious a problem with the cap as you do, and you have a real one. I'm with you.
And listen, when I read the Supreme Court's holding in the most recent case on this, they say we as legislators have the obligation to do the constitutional balancing test, and they've kind of said, look guys, y'all can do it as long as you have a good state's interest reason to balance out taking away somebody's right to get full justice. And we do that workers' comp with the workers' comp compromise, and we've done it in the med-mal compromise, and both of those have had to been tweaked over the years to make sure that the parties balance out. We just did major workers' comp reform, and so let's go back to the neurosurgery, because that comes up a lot, and I've talked to a lot of pediatric neurosurgeons. Let me just tell you this. If you're a pediatric neurosurgeon, and I bring my child to you and say they have a tumor in their brain, that pediatric neurosurgeon sits me down. He goes, these are all the things that can happen once I take off part of your child's cranium, and I roll back the layer of protection to the brain, and I get past the blood barrier, and now I'm in the frontal lobe. Okay, Your child can become bipolar. Your child may not be able to smell things anymore. Your child may not recognize you through their vision. They may have to come touch your face because they may be blind. We're going to have them sedated. So they tell you all the things that are the standard of care that could happen. The way we protect the pediatric neurosurgeon who has a gift from God to work on kids with brain tumors and things or spine tumors is that typically those results are within the standard of care. And the panel is going to say, this was a horrible thing. This child had a brain tumor. It's within the standard of care that the child could die on the table. Okay? What this does, and we could use an OB type situation, or we could use an orthopedic situation, because those are where this usually, what I've heard of, come into play. Your child goes in for a rotator cuff surgery, they put him in the proper position, and your child's allergic to morphine. They give the child morphine. They stop breathing on the table, they try to resuscitate, it doesn't work, so they're out for 30 minutes. Global hypoxic ischemic event. The result is cerebral palsy, maybe one limb, two limbs, all four limbs don't function anymore. And it comes back to saying, hey, you know what? If the nurse just had positioned you properly, this wouldn't have happened. That was below the standard of care. Mm-hmm. Now, if you have one doctor say that in the panel, you have two say it was okay, the cap doesn't get raised. You have to have all three doctors say, wow, this was below the standard of care and it caused the damage. We're not going to see that in I don't think we'll see that in pediatric neurosurgery cases, because if a doctor is cutting on someone's brain, that family already knows there's a chance of death.
Or they should know.
And they do.
Well, you say that. I mean, and obviously that is a good practice. But my experience, and I don't do med mal work, but I can assure you they're not going to sue them and say they didn't do anything wrong and they were within the standard of care, but I'm suing them anyway. So
right.
You're going to end up in court on it.
And it's a real emotional process.
Mm-hmm.
The families are emotional about it. The doctors are emotional about it. And that is why the safeguard is in there of the unanimous panel or the unanimous jury. Those are highly unlikely in the procedural process that we have. So,
and again, I'm not trying to at all be unsympathetic to what your situation is. What I'm saying is there are going to be doctors that are already calling us saying with the way that we're financing healthcare and a lot of them are just hanging up there are quitting. And I think I believe, and again I'm not exactly sure where we're going with this, but I think you're going to affect a tremendous number of physicians with a severe increase in malpractice insurance to cover a very limited number. And again, very serious cases. I'm not making light of the situation. I just think that you're going to have, I don't know how an insurance person can fix that rate in the abstract. You just say, well, you're an orthopedist. You could perform the same type of situation you talk about, and you could be subjected to it. So I got to treat you just like every other orthopedist, and your rates are going to go up. So again, that's just. And I'm just saying that back in '70, I think one of the reasons that the cap went on was to encourage so as to not discourage doctors from practicing medicine in this state. So.
I think you're presupposing two things that are theoretical, but in practice, when you talk to doctors and you say, look, do you feel like your patients should be at least fully compensated if the unknown happens during surgery and one of your staff members falls below the standard of care, gives too much anesthetic, doesn't position the perfect person right, and all doctors, and most of them go back to their Hippocratic Oath and they say do no harm. Mm-hmm. And they'll say, look, off the record, I'm okay.
Off the record, but do no harm, and on the record, do $500,000
Right. And so here's the thing, Senator Martini, and I think what you've just done is what I've been doing, and what you just did is you attempted a justiciable balancing process of two rights of people. And we've created that fiction in Louisiana. And the state court has said we're forced to do that balancing test. And you've just balanced the doctor's rights and the patient advocacy, you see. And we have to continuously look at that. I was so surprised that no one has we haven't raised the cap for over 40 years. that no one has thought this through and said, hey, this is a pretty unique way to handle catastrophic injuries. We've created no subclass in 40 years, and this is the worst of the worst. And we're not talking about the majority of cases that get to the panel stage. We're talking about, on average, 4 of these a year. Now, if an insurance company says, out of the millions of surgeries we do in Louisiana every year, this could happen 4 times, so you're a urologist, I'm going to raise your rates $5,000 a year. Well, that's a scare tactic, because we know just with basic underwriting analysis that you can't take a four out of a large number of surgeries and gouge rates like that. I think the doctors would say, look, this is a highly unlikely situation to happen.
Well, look, I understand what you're saying, but I also understand this process. And if we are to pass this bill, you can't stand here and say, and I promise you, this is the only time we're going to deal with this issue, because somebody's going to come behind you next year and say, my damages are just as bad, if not worse, than his. And then I think as we start picking away at it, then you get into an equal protection thing, saying, well, wait a minute. We have doctors saying do no harm. And we've got doctors out there causing millions of dollars of damage, and they're protected by the cap, except in this very small number. And I'm not saying it's not warranted, okay? Except I think that number. I mean, I can see what's happening. We're going to get the camel's nose under the tent thing. It's going to be a yearly thing where we say, well, you did it for Ryan Gaddy on his bill, and you did it for Rick Ward for his constituent. The next year, we're going to just start carving away. And I just think there are things that need to be considered. Sure, I'd love to see. There's no way, in my mind, knowing your story, that we can adequately compensate the Gaddy family for what you're going through. I understand that.
Oh, and I'll let you know this.
And this isn't going to affect you, but what I'm trying to say, the people you're talking about.
And I'm going to speak to that because we've gotten a lot of those red love letters that they send you in your email. Like, you're crazy for doing this. This is a personal vendetta. I mean, this happened.
No. I think it's a personal observation, and I'm going to
tell you this. Susan and I are in a unique position. We high school sweethearts, went to LSU. I proposed to her at the bell tower. I was Catholic, she was Baptist, so I said, we'll have a big family. They'll just all get saved. We had a lot of fun, all right? So we have 4 daughters, We're pro-life, we're prolific. That's what I tell folks. So Rebecca is our 3rd child. We were told by our doctor that hurt Rebecca that there was something wrong with Susan's uterus. That's why this happened. 6 months later, we go to that doctor's partner after he's had several issues happen at the hospital. Right. And I said, doctor, we just want to know one thing. Can we have other kids? He said, of course you can. There's nothing wrong with you.
Yeah. So
I'm telling you that there's a process that is buffered there that allows some bad behavior to happen. And it's significant. Now, this happened to us 9 years ago. I mean, our whole life has changed over this. And this is not about me, because you could pass this bill or not pass this bill.
Well, if I gave the audience the impression that I thought it was I just think it's a personal situation which motivates you to do it. And I don't mean that in any negative way.
No, and I'll tell you this, and a lot of what we do as senators is motivated by personal experience.
Well, of course.
Whether, it's something in our district or a constituent concern. And Susan and I debated about whether they're even doing this, but there's so many folks that this has happened to who don't have a voice, and they can't come down here for $16,000 a year and be a senator. They're dealing with their child. I mean, I was going to prepare a statement to write this morning, for an opening. And I realized we had to get Rebecca up. We had to give her medicine through her feeding tube. We had to do all these things. And we decided we're going to drive over here. We're going to push her over here in the wheelchair. And I thought, man, this is our new normal, And I thought all the folks that are coming here to testify, they might have said, those steps are too high, or this is too much, I'm just not going to come. So this isn't, Susan and I are way past, this is our new normal. This is how we live. Our youngest daughter does not know what it's like not to be, she holds her big sister. Mm-hmm. It is such a unique situation. God has worked through our testimony and put us in this place to share this information with you, because you know, what you're really doing is you're saying, I'm going to balance these situations as they come before us as Senate. I'm going to balance the justice that is there. And you know, as a dad, when a doctor wrote me an email, the only one that really got me was he goes, I can't believe you're doing this because it's personal and my assets are going to be at stake. And I'm like, yeah, I didn't respond because I know he was just talking out of a little bit of anger. He probably got an email from one of the red cards and they told him your rate's going to go up 1,000%, you know, and whatever they said. And so they're fired up about it. But I want to tell you this, he's right in a way, because you have to balance the asset of a child's brain to a family versus his ability to keep his assets. Okay? And I want to let you know something scary. When we're allowing direct access and some of the things we talked about, those are capped too. You know, all the arguments we just had on the floor, well, if a physical therapist says this is a pulled muscle, but it's really a cancer tumor, well, we can have direct access in a state with a cap. I mean, we've already agreed ahead of time that mistake is only worth $500,000, and the practitioner has to pay $100,000 of that. So we're kind of have this snowball effect going. But you didn't bring up that this was a personal thing for us. Other people had. I don't want you to think that I.
And I surely didn't mean to insinuate
Of course not.
that.
I understand that.
You know, so.
Yeah, but I will tell you this. Susan and I have advocated on this for a while. We've met with many families with special need kids from birth injuries or orthopedic injuries, and we love on them, we care for them, and then we kind of commiserate, you know. And it's not about money, you know. It is not about that. On the plaintiff side, I mean, when you have a child with severe cerebral palsy or who's a spastic quadriplegic, I mean, you know, at some point you just say, I'm going to file bankruptcy or I'm just all in. You know, I'm going to spend everything I have to keep her where she wants to be. It's the families that can't afford it that we're really advocating for, you know. And they go in, and it's a routine thing, and the doctor weeps with them and says this is horrible, and they get forgiveness and they give forgiveness and they make it through, and then they sit down with someone and they say, hey, and they sit down with some lawyer who tells them, hey, in 1970 they decided your child's brain was worth $500,000, and you literally add insult to their injury. And so what this bill does, it just carves out the worst of the worst. And once again, I think that anything we do will be used by the insurance industry to raise rates. Anything we do. I mean, every bill they look at, I mean, I've had discussions with my other bills that I have to decrease the rates of businesses, and they say, well, even if your bill passes, we're not going to decrease rates. And so, you know, and that's just the nature of the beast here in Louisiana. So, anyway, this is my notes to say I have one line, so everything I've said has been.
Well, we do have another question from Senator Luno.
Thank you, Mr. Chair.
Thank you, Mr. Chair. Senator Gaddy, I'm gonna ask you to do something for me. If you don't want to, it's okay. I don't think a lot of people understand what we're talking about here would happen. I'm going to ask you, if you would, to share what happened with your child and your wife. If you don't want to, that's okay. I know that may be very difficult
Well,
to do.
you know, it is difficult, but, you know, we've had 9 years to kind of process this. And so if you don't see me cry, please don't think, well, that guy doesn't love his kids. You know, just know that we have talked about this in church. We've talked about this with other families. So Susan's going to get mad because I think she wanted to tell a story, but I'm going to do it because I know she doesn't like talking about it, okay? On April the 24th of 2007, we went into the hospital to have our third child. I was at dance class with my two older. I wasn't dancing, but it was my job to take them to dance class. I look like a bear doing I dance. So I was at dance class with them. Susan called and said, "Hey, doctor's concerned." She was 38 weeks. She says he wants you to come in. So I called my mother-in-law, which is always a fun situation, to have her come to dance class so that I could go to the hospital. So I go up to the hospital, and the doctor decided to break her water early, and it was just one of those processes. And to make a long story short, there were about the panel agreed there were at least 3 opportunities for him to do a C-section that would have lessened the hypoxic ischemia or the non-oxygen to the brain injury that Rebecca has. I was in the room as a dad videoing. My two oldest daughters, we were 7 and about 5 at the time. We're in the waiting room with all of our big family, videoing, interviewing people. Hey, baby's going to come here, come soon. What do y'all think? That was about 5 or 6 o'clock. And about 9 o'clock, Susan's blood pressure fell. She turned white as a sheet. She needed oxygen. The nurses came in very concerned. About 9 o'clock, she had what's called late decelerations, which is when the fetal strip shows the baby's in distress. You know, without getting too technical, there were some decisions made. I remember vividly the doctor saying, well, those external monitors are not working. That's the problem. So when a baby's being born, when they're down in the birth canal, they put in an internal monitor on the baby's head before they're born. That way you get a true reading. Well, we found out later that when he did that, he misplaced the internal monitor not on Rebecca's head, but on Susan's cervix. So he was actually reading Susan's heartbeat instead of the baby's. A couple hours later, Susan's blood pressure began to fall, which is a classic sign of a rupture. It means the blood that usually goes through the placenta to the womb. It means that there's a leak, but it wasn't a open rupture because Rebecca was already down in the birth canal, so she was kind of acting like a cork. The blood was pulling behind Rebecca in the uterus, and portable ultrasound was brought in by the nurse. They put it on on Susan's tummy. Even though the reading was 120, which is normal, the portable ultrasound read 50 beats a minute, which is horrible for a baby. And so there was kind of a freak out mode. There was nobody on that wing of the hospital. We found out later an orderly was called to help with the delivery. The anesthesiologist, who did an excellent job in resuscitating Rebecca, I mean, he was very devastated. The doctor was devastated. Did a C-section. They called for a C-section. It took 28 minutes to get Rebecca out. We found later out at Dallas Children's Hospital when we were there with a neurology team that it should only take about 3 to 7 minutes. They have like a team always on call to get a baby out in distress because of this. When they finally got Rebecca out, she was dead. There were 2 units of blood coagulated in Susan's uterus, which means she'd been bleeding for a while. And there was a unit that was free floating, so my wife had lost almost 3 units of blood. I did not know Susan's life was in danger. I was never told that until afterwards. They measure a baby with APGAR scores, which is a 0 to 15. You know, are they breathing? What color are they? How are they responding? And 1 to 5 on each of those. And different hospitals do it different ways, we found out. But she was 0, 0, 0 at 1 minute, 5 minutes, 10 minutes, and 15 minutes. So she had been dead for 15 minutes. They revived her finally. She immediately started bicycling. They call it a bicycling seizure. So she would move her. I mean, she's a baby. She looks just like my oldest daughter. I mean, spitting image. You put their 2 baby pictures together, and she and Catherine look exactly the same. And so she began bicycling her arms and legs. And, you know, baby doesn't do that. We all have kids. I mean, babies don't do that when they're born. And so I went to the NICU. Susan stayed at the hospital, and they were at separate locations. And that's when we kind of got the news. A friend of mine that's a neurosurgeon called me. He said, I looked at the MRI. It's black. I said, what does that mean? He goes, there's just nothing there. She's a vegetable. And so we kind of had hope and we had prayer, and we called all of our friends, called in all of our favors, called in everything we could do to help her get the best care possible. Susan, being a PhD psychologist who had worked with kids with brain injuries, she knew the outcome. I did not understand it because most people I knew that had strokes or brain injuries had recovered. They had been able to have some quality of life, you know. So we found out we found out it was the worst case scenario. We got to Dallas Children's at the ER one night because Rebecca had had a seizure for about 24 hours, and it wouldn't stop. And we left the Shreveport Hospital. I called a friend in Phoenix. He said, get to Dallas Children's. We'll have somebody there to look at her. Because she was hitting milestones, but because her brain was kind of fried, it was just it was just totally dysfunctional. And we couldn't figure it out. And so we got to Dallas Children's, and the first question they asked me in the ER was, did you have this baby in a hospital? And I said, yes, sir. He goes, this is pathetic. Pathetic. And so anyway, you know, it was a pretty tough time for us. None of this was done intentionally, though. I mean, it was just a mistake. I mean, we know to this day, by praying about it, there's no way anybody meant for this to happen. That's not what the Med-Mal Act is about. This was just one of those situations that was really bad. Now, since then, you know, we go to Shriners, we go to different places, we try to get Rebecca the best care and the best comfort. You know, one night at Dallas Children's, they asked me to sign a DNR because she wouldn't stop having seizures. I mean, bicycling seizures, clonic seizures, tonic seizures. She wouldn't keep anything down. Even her medicine, she would throw it up immediately. And, you know, she's a baby. I mean, she's like less than 6 months old. And so they said, Dad, will you sign a DNR? And I said, look, I'm pro-life. I'm not going to do that. You know, I want y'all to fight for her. And so we made it through that. And, you know, she's still here today. She's had, I think she's had a pretty good life. We take care of her the best we can. We've hired somebody to come to our house and sit with her, Miss Kathy, who is like Alice and my favorite. Like, if you could dream of your favorite mother-in-law, that's Miss Kathy. She loves me. You know, she cares for the kids, but she loves me. You know, and she came to us just sitting by God to be at our house every day. It allows us to have some freedom with our other kids. A lot of families don't get to have that. You know, I got to coach softball. I got to do a lot of things with my older girls to make sure that their depression didn't grow and grow and grow. You know, and then we had Charlotte, which was kind of a surprise. And so, but anyway, you know, our story is no different than anybody else's. You know, can we articulate it a little better? Probably. You know, but as we meet more and more folks who have suffered through this, it's a tragedy. And I'll tell you this, Senator Luno, and what we found over the years is that this is not training issue. This is because the cap is so low. Sometimes this happens. If we would have been on vacation in a state without a cap, I don't think this would have happened. Don't think it would have happened. We have a high rate of medical malpractice claims here in our state with a cap and with a procedure that is tough. So, but I'm not here to bash the procedure we have. The Supreme Court has said we have the right as senators to look at this and work on it and determine if there's classes of people that should get more or classes of people that should get less. And so, anyway, that's kind of a peek into our story, but it is tough to talk about. And honestly, a lot of people that were coming today just said emotionally, I can't talk about it.
Right.
You know, Ryan, you tell your story, you advocate for us, but we're not going to come.
I appreciate that, Senator.
Thank you. And I'll just add we had a unanimous panel. The panel unanimously said, we agree this fell below the standard of care, and that her brain injury was caused by the doctor's decisions. Now, please note, we had to have genetic testing done, because at first they told us that's what it was. We had to have Susan examined because they said your uterus is tilted and you have a propensity for placental abruption, and that was ruled out. Can't have any other kids because of the biology of your family. I mean, I cried that day when we found out that we could have other kids, you know, because I really thought that was kind of a low blow to us, you know, to try to lead us on in that way. And then we found out that other people have gotten the same kind of stories, you know. Hey, it was your anatomy. That's why this happened. And so we're finding out, you know, those things. So, and once again, some of my best friends are doctors, you know. They do excellent work. They care for their patients. One of my friends slept at the bed of a mother for 2 nights to make sure that she was cared for after a horrible birth situation where she showed up at the hospital abrupted. He stayed there in the room with that baby and the mama, praying over them. You see? And that wasn't a breach of the standard of care at all. He was there 100% with that family. So anyway, I appreciate that question.
Right now, I don't think we have any more questions for you. We do have some cards in support, some that would like to speak. Ms. Susan, would you like to come forward and speak now? Also, we have here in support but not wishing to speak is Benjamin Mouton. We have Chantel Nixon with herself and her son, Kay Swan, and then we have also here and would like to speak. And then we have Scott Weber is here but does not wish to speak.
Say your name and address first.
Yeah, if you just would
I don't
identify
believe
yourself.
anything he says, so I'm going to follow your lead. Does that work?
Yeah, if you could just identify yourself
Okay.
For the committee, and then you can go from there. I don't think your address is necessary, though.
Maybe changing soon. No, my name is Susan Gaddy. It's probably just as well that Ryan gave you the spill on all the medical terminology for the history of my child, because I kind of gave up on that a long time ago, but him being the researcher and the intelligent one he is, continues to do that. I think the best way for me to present Rebecca to you, other than I think most people can't understand her until they do meet her, because she is quite unique. We're used to the stares, we're used to people looking, we're used to the different comments, we're used to, oftentimes people will think that she's an infant because of the brain injury. Her head is so small and she likes to be cuddled up in my arms. So there's a lot of mistaken things, and we're accustomed to that. But one of the most often questions I often get are from kids. And I appreciate that, because I always appreciate kids' honesty. They ask what's wrong with her. And the way that I best explain that, and I think maybe the best way, is I say her brain is hurt. And they say, kind of look at me confused. I say, well, what does the brain do? And they all say, well, the brain is how you talk, how you think, how you move, right? Because when you injure the brain, you injure everything, right? So that's basically what happened to Rebecca. As a result of the birth and the mishaps that happened during that process, her brain was so significantly injured that she, when you met her, I know many of you were probably confused, but she is not able to see. She does have cortical blindness. However, her hearing is intact. And so when she hears a different voice, for example, Senator Luno walked by the other day and spoke, and she kind of jumped because she can hear, so her hearing is very well intact. However, she really does not have any functional movement of her body. She can lift her head for a few seconds at a time. Never reached a developmental level of more than a 1-year-old, because she's never received that social smile. So as a parent, we don't get that reciprocation for now. I had things planned. Yeah. In terms of when he spoke about the unanimous panel, I can remember the day that the unanimous panel came back for our child, saying that, in fact, all the concerns that we had brought forward were legitimate. The physicians on that staff had also brought into that meeting additional concerns and additional problems that they had seen with it. And I remember at that day, because I think oftentimes people have a perception of persons as pursuing financial gain as a result of their child's injury. And I can remember that day vividly, because I remember sitting in my husband's office and I remember crying hysterically, because all that I really wanted to hear back from that panel was that that doctor had done everything he possibly could for my child. You know, I didn't want the money. I didn't want anything else. I just wanted the peace of mind knowing that everything had been done for her that could have possibly been done. As it turns out, that's not the case. So we got the lesson in forgiveness, which we have given, which is the greatest lesson that we've received. But having a child with a disability, and how would you label her disability? Formally, well, you could say that she has uncontrollable seizures, so she's an epileptic. You can say that she's a spastic quadriplegic because of the orthopedic impairments. The brain injury has done a significant amount. For example, when you look at Rebecca, the size of her head, like she can still wear an infant cap because the head grows as a result of the brain growing within, but because so much brain matter was lost in that initial injury, her head is much smaller. Even to her teeth, I call her my little British baby because of all the seizure medication. Her teeth are very yellow in spite of the best care that she can have. She's unable to cut through teeth, so they sit there and she drools nonstop all the time because she can't cut her teeth because she can't eat. What else? The greatest concern that I have for my child and the biggest impact that it's had on her are all the neuromuscular issues that she receives as a result of this. The technical term for it is they call her hypotonic, because if you were to take your arm and twist it like this and hold it as hard as you can, as long as you can, that is the state that she basically stays in. So it deforms her body to the points where her hips are twisted and completely out of socket. So when you look at her, she has scissored legs and her hips stay out of the joint and kind of move around within her body. You can actually see the tops of her femurs whenever you change her diaper. And that, I think, is my greatest concern for her, is the physical discomfort that she receives on a daily basis as a result of that. She does have uncontrollable seizures, but it's crazy at this point in my life. The seizures really don't bother me. It's more of the muscular pain that she has as a result of all this. I outline that to say the burdens that the families of victims experience are extreme. They're extreme emotionally. They're extreme behaviorally. They will put pressure on a family to where the family dynamics of children with disabilities, not many families survive that, not many marriages survive that because the burden is so great. And if there's a way to relieve the financial burden that adds to that stress in a way that is more just for persons, I would love to be able to see that for the families that I've encountered. Because as we went through this campaign trail, I believe that the majority, I didn't realize why I was on the campaign trail as much as I was, but every time I went, everywhere I went somewhere, there was a special needs family member represented somewhere. There was someone that had a story about their child. Even as I sat here watching the TV with persons with disabilities later, you know, there's a burden for us to care for the disabled, and how we care for our disabled indicates how we are as a society. And I do think that it's just for persons to help in that process that are a part of that. Does that make sense? So for when your child is hurt and they look at you and they say your child's worth $500,000, you know, I've often heard my husband witness to many people, and he has said, you know, would you sell me your eye for $1 million? Well, no, I'm not going to sell you mine. Would you sell me your arm for $1 million? Well, no, I'm not going to sell you my arm for $1 million. Why? Because it's precious, right? So as a parent, as a mother, I would never wish this on anyone, okay? There is, like y'all have said, there is no financial compensation that makes it okay. There's no financial compensation that any of you would take to say, if I gave you this amount of money, would you give your child this injury? Nobody in their right mind would accept that, right? But having said that, I do think that there should be a just process in place. And I do want, for us personally, because it has been said that we are on a personal vendetta for this. We have no vendetta. We love our child. She's changed our lives drastically. She has brought perspective that we call our 1,000-year perspective, in terms of whenever we look back in 1,000 years, the lifetime that she would have spent here will just be a blink, just be a dot on that line, and we'll have eternity with her. And she is my only child that can't mess up her eternity, in my opinion. The rest of them are up for grabs because they make mistakes all the time. But I don't know. I mean, I don't know what else to say. I didn't really prepare very well. Yeah, thank you.
Well, no, thank you. I know this wasn't easy. Personally, whenever people would maybe attack you through emails or something for bringing this bill, I take a little bit of offense to that for you, because I think sometimes we come here not necessarily knowing why we were sent here, and then we find out along the way that maybe this is something that I can shed some light on, whether it be this issue or other issues, and you do take that chance whenever you're willing to bring it forward. And regardless of what happens with this bill today, I think it's very important that we hear this particular side of it. And so thank you for being willing to deal with those things in order to have this conversation.
Well, and I do think, as he said earlier, it is personal, but I think most people, I watched someone from the floor last night advocate for a bill about engineering. Why? Because it's her personal experience, and because she knows from her personal experience how to make it better. So I think oftentimes we wonder and we pray, why is Rebecca still here? Why is she continuing to suffer? And I know that God's plan is better than our plan for her. And I know that she is still here as long as there is a purpose for her to be here. So if this is part of her purpose, to shed light on injuries that can happen and how drastic they are to children and how they can affect families and siblings on all kinds of levels, I would hope that she could do that. Hopefully people will be able to look at our family and see how she strengthened us in many ways as well. And it is an opportunity for us. I appreciate the opportunity that she's given us to be able to help other families with special needs members, because like my husband said, I am a psychologist, work with children with disabilities all the time, never planned on having a child with a disability, mind you. I don't think any of us do. However, it's made me a better psychologist, because you can never really understand what it is that families go through until you experience it yourself. So thank you for your time.
Thank you. We have Ms. Chantrell Nixon that's here and would like to speak. We also have James Click that is with, I believe, Ms. Nixon, and is here as well.
I'm her lawyer. Thank you.
Thank you.
Good morning.
Good morning. You can identify yourself and then you can speak.
My name is Chantrell Nixon, and I want to start off by saying I'm very emotional, okay? So I am going to present tears just off of his story alone. When I see parents that go through the same thing that I go through, and I feel very, very thankful because we actually have someone that understands what we go through to advocate for us. So whether someone feels like it's a personal vendetta or not, I think it's awesome. You know, I say this all the time. You never know what a person's going through until you walk in their shoes. Everybody has different shoes. Everybody has different walks of life. And just going off of someone telling you, you know, their story, or you kind of seeing but not seeing, you know, you never know how a person is internally. And the things that we do as parents with special need kids, it is a job in itself. Being a mother, period, is a 24-hour job. But when you add a kid that has needs and you have to be there, there's not enough hours in the day to compensate for that. And I think that, you know, to speak on what Senator Mark was saying about the insurance claims going up and all of this, you know, creating a domino effect of other people coming in saying they want their cap removed to all of that. I feel like what Senator Gaddy said was correct. It'll kind of like wean out the ones that's not performing the way they should. If you do raise them, maybe that's what they need. to raise their medical malpractice insurance, then some of the things that's happening won't happen. Maybe they'll do their procedures, with a fine tooth, or look over everything, think about everything that can possibly go wrong or not go wrong if they do something different, and not just pass it off as, like I was passed off. I was paranoid. Maybe if I was in a different situation where I had better doctors, or they had that higher insurance, she might have said, well, maybe I should look at this kid a little closer. Maybe I should listen to what the mom is saying, and if that's something that has to happen, then it has to happen. Like he said, insurance company raise insurance for bad weather, for anything that they think of, they'll adjust your rate. So why not have it to where we can wean out doctors that don't perform, to their standards, when we have phenomenal doctors. So, and I'm a hard worker. I was a hard worker before I had kids. I'm the mom that had to file bankruptcy, because when I had my child, there wasn't a doctor that was going to tell me that he couldn't walk, and I wasn't going to listen. I wasn't accepting that. I was told that he wasn't going to walk. I was told that he wasn't going to talk. He wasn't going to do these things, things that a normal kid should do. And I remember when the doctor told me that, and she said, Miss Wine, did you hear me? And I told her, I said, yes, I hear you, but God might have a different plan for him. And as long as he has me, I'm going to fight for him. So yes, I was the parent that filed bankruptcy to take my child twice a week to Mandeville, which is 2 hours away, and pay for some specialized therapy that I had to pay for out of pocket, with the help of my church, my family, my church, people that did donations and stuff like that. And then just so happened, my aunt, she saw the same therapy that we were doing in the hospital in Lafayette, and she lives in Lafayette. So that made it easier. We still had to travel, but we had somewhere to stay. We didn't have to go back and forth. So we do what we have to do. Now, had I not been capped, I wouldn't have had to stop working. I could afford to pay somebody to stay with my child. I'm not as fortunate. I don't have Miss Catherine, is her name. I don't have a Miss Catherine, but I do have a Brianna, and she's awesome, and Kai loves her. But she can only do so much. I do have a younger son, and like Senator Gaddy said, she makes it possible for me to be a basketball mom and, travel and do things with. But with me, and they probably battle with this too, I do not feel comfortable leaving him. Okay? So we all have to go. She comes with us. Look, that's one of the phrases that he's learned, go take a ride. He knows that, if I call my dad and he tells my dad, go take a ride, my dad is coming, take him for a ride. I do not like to leave him out of anything. I try to make his life as normal as possible. And if it's a thing that I have to leave him, I feel awful. And he's getting to the age now, he's 13. He's getting to the age now where he knows that, we're going. And it's been time that he'll sit and just wait and for us to come through the door, And so he has a little brother, and like Rebecca's little sister, he also takes care of his big brother. He is an awesome little boy most of the time. most of the time. But he, as far as his brother is concerned, that look, the brotherly love that they have, like Kai will literally go and lay down and go to sleep on his brother. And so he'll take him, come on, brother, let's go to bed. Kai also has seizures. The little brother, Mama, what do I have to look for? You know, I was afraid to have kids after I had Kai. I really was. And I was afraid that what happened to me would happen again, and I didn't know how I would handle it. But like she said, God does things for a reason, you know, and God put my younger son in my life for a reason. And he steps up with his brother, and he literally helps take. He was the one at 2 years old, 3 years old. He's been walking since he was 9 months old. My 7-year-old. He's been walking since he was 9 months old. He was the one that helped Kai learn how to walk. I was in my bedroom, and I'm hearing him saying, "Come on, brother, I got you." And he'll take 2 steps back, and he'll make Kai walk those 2 steps to him, and he got him. And I watched him do that for at least 3 minutes. And so, you know, I think Kai seeing him run around, you know, kind of got him like, yeah, my brother's not going to leave me. So, you know, a lot of things that my younger son does, Kai kind of mimics. And his brain injury was, you know, severe. And I was told that you have to look at it as the older he gets, his brain has to catch up. Well, he's still functioning in some aspects as a 24-month-old, and he's 13. You know, and I totally agree with this what is this bill that's, you know, he wants to get passed. And I just it would help a lot of families that are in need, and it'll make life much easier. You know, to, like I say, you all may not understand exactly, you know, what we are talking about, but I see the compassion that you all have for him, because y'all actually see what's going on with him, but you're not. You see it, but you're not in it. You know, it's totally different when you're in it. So that's all I have to say. Thank you.
Thank you, Ms. Nixon. Thank you for taking the time to come.
Thank you for having me.
Would you like to speak?
Well, I just have a couple of comments, and one of the comments is there's been expert testimony in cases that has indicated that increasing the cap is not going to result in any significant increase in insurance rates. Also, there's been no change in the number of physicians when the cap was established between what the number of physicians that we were having. We had increasing numbers of physicians in the state of Louisiana prior to the enactment of the cap, and that same increase continued after that. So we have evidence along those lines. If ever you all want to have a real serious discussion about that, you know, we can present that evidence to you and address that.
We do have a question for you, if you don't mind.
Sure.
Senator Milkovich.
Thank you, Mr. Chairman. And Attorney, tell me I heard your name. Did you say Mr. Glick?
Click, K-L-I-C-K.
K-L-I-C-K. And your first name is?
What's that?
Your first name is?
Jim.
And where do you practice, Jim?
I'm in New Orleans with Herman Katz.
Gotcha. I had a quick question. Maybe a quick answer, maybe not.
Yeah.
You said that the experience has been that when the cap is removed, insurance premiums do not go up. What's your analysis of why an increase or a removal of caps does not increase rates? What's your analysis of why that is?
Well, for one thing, the states that have no cap on it actually have lower insurance rates than the states that have caps. there's a whole body of evidence. I mean, there've been trials on this whole issue where they presented many of these things and have gone through it, the evidence. And as I said, if you're really interested in it, I can go get it. I wasn't involved technically in those cases, but I can probably get the evidence and show it to you.
Sure. Well, and that information is important, obviously, because it has to do with the compensation of people that get hurt. And what is your contact information, Mr. Oh, you said you're with Russ Herman's law firm?
Yes.
You said that removal of caps does not increase premiums. I'm not sure you said why. And I'll suggest a thesis, and I don't know if this is it true that when caps are removed and there is more accountability in the system, that there's greater care shown so that there's less neglect? Is that?
That's exactly right. And that's the reason why the states with no caps have, generally speaking, lower malpractice insurance rates than the states that have caps. And it's one of the reasons why and you see it here, the cap hurts the most significantly injured people. You know, people that get the regular injuries, and the most significantly injured are a small number of these people, okay, to start with. It's a very small number. And so once you start, you're allowing the people who don't have the real significant injuries to get full compensation, but you're harming the people that have the most significant injuries.
This is potentially important information, Mr. Click. Thank you very much. Thank you, Mr. Chairman.
One more question, sir. Mr.
Sorry, I apologize.
Senator Luna has a question for you.
I apologize.
No
It's
problem.
okay. Mr. Click, with Ms. Nixon's permission, I didn't ask her to tell what had happened to her son, but with her permission, could you tell us, or could she?
I would, I
prefer
can't
she-
go into that.
Okay.
Because she can talk about the afterwards, because that was a full trial on the merits, public
Sorry.
trial.
We won't put you in that position. Thank you.
Thank you.
We do have some cards in opposition, as well as some cards that are here for information purposes only. I think we're going to start off with the information cards. We have Ken Schneider with Patient Compensation Fund. We have Clark Kosei with LAPCF, also here to provide information.
Gentlemen, I'm Clark Kosei. I'm the chairman of the Patients Compensation Fund. I've been on the board now for 12 years, and for the last 10 years I've served as its chairman. I want to start off by saying that we approve more than 99% of the cases that submitted. I've only remember one case that we have actually not approved a settlement on, where we thought we were not getting a fair deal. Just put it that way. I also want to tell you that on the micro spectrum that we've had today, our hearts are broken about 10 times a month on cases that show facts like these. But it's not our job, by the way, to punish doctors. We are not the licensure board. There's a licensure board called the Louisiana Board of Medical Examiners that gets reported from us on any claims that we pay, in which has the opportunity to have hearings and decide on whether or not that doctor is fit to continue practicing. Not our job. We do experience rate doctors that have substantial amounts paid out over and what they pay in to the Patients Compensation Fund. We're not an insurance company. We're state created, and the law that we have has been criticized many times. But we didn't write it. It was written by the 75 legislature, but they didn't write it either. It was basically taken from Indiana in 1975, word for word, and where the word Indiana was, they scratched it out and just inserted the word Louisiana. So it's a little foreign when you practice med mal to when you compare it to the law that we have in other areas like 2315 lawsuits and automobile torts. A doctor can pay what a surcharge can get to be 50%.
Yes.
They can have a substantial surcharge based upon their losses to the fund. Now remember that scheme, we have two levels, we have two layers. We have the underlying, which is the first 100,000, and we have the next 400,000, exclusive of judicial interest and medicals for the claim. The defense of the claim is based upon the 100,000. The underlying insurer or self-insured is responsible to defend the claim, not the patient's compensation fund. We basically have to pay the bill, but we don't get to defend the claim in most cases. When we first started up in 1975, it was a checkbook, pay in, pay out, and very little insurance type concerns. We didn't have, they didn't have, I wasn't involved then, but I've learned a lot about it since then. However, over the years, there was a large bit of concern that if we were insolvent, that there would be a hickey put on the state, that the state would have to bail out the fund, because we were state institution. We had state employees, we still do. We have state civil service, we still do. Although not $1 of the money that is in this patient's compensation fund is state money. There's not one tax dollar involved. We pay all of our bills with the surcharges that we collect. Excuse me. So the concern about that was a concern of the Department of Insurance. And in fact, there was pressure put upon us to make sure that our rates were adequate and that they were actuarially correct. And to that end, the Patient's Compensation Fund added extra rate on over and above the amount necessary to pay the claims in order to cover that unfunded liability. When I arrived at the Patient's Compensation Fund in 2002, I think it was, the unfunded liability of the Patient's Compensation Fund, just like the state's unfunded liability for its retirement systems, kind of, was over almost $500 million. It meant that there was a potential that should the world end and we stopped receiving money in the surcharges, that there would be $500 million we couldn't pay. So we added rate every year in order to start covering that unfunded liability. And in fact, I went to see the commissioner a couple of years ago with the good news that despite the fact that he was concerned about that, we have covered our unfunded liability. So today, if we were to pay all of our claims to the ultimate, which is an insurance term, to the end of the line, we would be able to cover them. We were also concerned about being swept. During the last administration, there was a lot of talk, and in fact, a lot of independent or quasi-governmental entities like ours had their funds swept into the state general fund to pay the bills. And a very large amount of money, all committed to case-based reserves. They committed to claims that we have or will have. Should not have been swept. And so the legislature passed a constitutional amendment and sent it to the people. And although we did not spend a dime on passing that constitutional amendment, it passed by, I think it was like 52%. Not a landslide, but we didn't spend any money. And basically got newspaper support in Shreveport and in Baton Rouge. We didn't get the paper in Monroe. I don't know how Shreveport and Monroe split up, but we didn't get the paper in Monroe. We didn't get New Orleans. But we did carry most of the other big papers, and that's how people vote lots of times on constitutional amendments. The constitutional amendment did a couple of things. One, that it separated our money from the state budget. So we're no longer in House Bill 1. We're got our own pile. Secondly, it said that if we ever got into a situation that there would be no hickey on the state, that the state is not responsible to bail us out, and that we couldn't send them a bill to cover our losses, and that we had to be, to that end, we have to be actuarially adequate. We have to have rates that cover the losses according to a properly credentialed actuary.
Mr. Kosei, and you may be getting there, but just for the purposes of time, could you kind of
Yeah, we're gonna get
limit
to
your
the cost.
comments to how
Right.
this bill would affect?
Well, we got, and that's my next point, and that is that we have to make sure that we cover our losses. So I'm gonna, I'll stop there. You know, you see now that we have this responsibility, and this is Ken Schnauder, who has contact with the actuary about this legislation.
Thank you, Mr. Chairman, Committee. I'm Ken Schnauder. I'm the Executive Director of the Patients' Compensation Fund. When Senator Gaddy filed his bill, I knew that there would be information needed on rates. So I immediately contacted our actuary and had him run numbers for the benefit of if this bill passes in its current form, what effect it would have on rates at the PCF. The majority of the claims that are paid, majority of the dollars, and the majority are Patients' Compensation Fund dollars. Granted that we have 400,000 plus all of the medical bills beyond the 400,000 that we cover, as opposed to just the 100 on the primary side. Give you an example of if you raise the cap from 400,000 to 4.9 million, excess of the 100, just that increase in the potential, the limit, would cause a 4.5% rate increase across the board for every enrollee. We have 23,000 enrollees in the Patients' Compensation Fund. What that is, that's without a claim ever being filed that hits this 4.9 million excess. That's simply like you taking your auto insurance and going from a 25/50 policy to a 100/300 policy. Whether you have a claim or not, the charge for that, the potential for the claim is there, so the charge is more. So that's a 4.5% increase across the board on every provider. For every $5 million in claims that we would pay, whether it be 2 claims at $2.5 million or whatever the scenario for frequency, but for every $5 million we pay would be a 3.6% increase across the board. Now, as Senator Gaddy mentioned, we have an average of 4 severe brain damage, minor cases a year.
Minor, M-I-N-O-R. Younger than, yeah, children.
Children.
Right.
So, you know, the actuary, if you took, say, 2 cases that went to 5 million or 4 that went 2.5 apiece, whatever the scenario, but you spent $10 million, that would be 7.2% increase plus the 4.5 that's already there. So it would be a minimum of 12% increase across the board. I'll put that in perspective for you. An internist, family medicine, that would be about a $1,500 a year increase to their medical malpractice insurance. An OBGYN, it would be about $5,500 to $6,000 a year increase. To a large hospital group in this state, it could be $5 to $6 million in increases. And you say, well, why would it be across the board? Main reason is virtually anybody can have a brain damaged child claim. I've had them on dentists. We've had them at hospitals. We've had them for internists. We've had them in the emergency rooms. I mean, you can't segment out who could potentially have the claim until such time that you have 10 years of credible data that shows you where these claims have occurred. So that's the financial impact on the Patients' Compensation Fund from a rate standpoint, which goes directly to the healthcare providers in the state. Their costs immediately go up.
How do our rates compare to other states, and specifically maybe with states that have higher caps or states that have the same lower caps? I mean, overall, where do our rates lie?
Our rates are, for years, we were in the top 20% in the nation. But let me reference something. If you look at numbers, that's more from our law and our litigious state, because our auto insurance rates are always in the top 5 in the nation. Our homeowners insurance rates are always in the top 5 in the nation. Our general liability rates are always in that segment. So you're not really comparing apples to apples when you compare us to other states, because we're a different state altogether. But our medical malpractice rates have come down since we have, claims have dropped over the last 5 to 6 years. Our rates have dropped 40% across the board over the last 6 years. But we are still about at the 50 to 60%.
What's caused the rates to drop by 40%? Is there anything that shows why that?
Our claims frequency has dropped, but it has nationally as well. But it has dropped in the state. Also, the board has taken the position that once we became funded to where we have enough assets to cover all of our losses, then we're not going to charge rate higher than that amount, even though the actuary says we should. Last year, the actuary said we needed a 3.8% increase in rates. We gave a 13.9% decrease across the board because we had reached a level where we have enough assets to cover all of our losses at this stage. That could always change. It could go up or down from this point. But, medical malpractice insurance is a large cost of the healthcare system. So, we're not an insurance company. We're not in the business to make money. We want to provide the best we can to the healthcare system, being it paying claims and reducing the cost of medical malpractice insurance for the healthcare system.
Just to give you I want to address that question, please. There's a publication done by the insurance industry called The Monitor, and it compares not workers' comp, medical malpractice rates among the states. And over the last 8 years or so, I had a study done of that study. And for years, we were neck and neck with Texas and Mississippi, and far below Arkansas. The only state in the South that we were not ahead of as far as costs are concerned was Florida. And in Florida, it has no cap, and Florida has substantial numbers of med-mal cases, and it's very expensive, maybe twice as expensive, or 50% as more expensive than Louisiana. Texas and Mississippi both adopted caps on non-economic damages in the late 90s or the early 2000s. Their rates went down substantially and were below ours. But since we have gotten funded, and funding the losses was part of our biggest problem, since we've gotten funded, we have been able to lower our rates, and I think we're competitive. And our goal has always been to be competitive with our neighboring states as far as costs are concerned, but we'll never be where Arkansas is. Arkansas is substantially more efficient, if you will use the word, as far as malpractice costs are concerned, than Texas, Louisiana, or Mississippi. So that's partially answering that question.
Senator Milkovich has a question.
Thank you, Mr. Chairman. I think I want to start on a point of agreement. Would you all agree with me that Louisiana has some of the finest physicians in
Absolutely.
America?
Yeah.
And would we also agree that sometimes you can get bad outcomes when doctors have done everything they could and really probably done everything right? Do we agree with that?
Certainly.
In other words, some bad things can happen in medical settings without medical negligence, but because of the complexity of medicine, because of the innate condition of the patient, because of the factors of different pathological processes. In other words, you can have people that do poorly in medical care without doctors making any mistakes at all. Do you agree with that?
Yeah, I have a personal experience like that. I'm walking around with a drill bit in my knee. Not the doctor's fault, but when we got it, he's the best doctor I could find in Baton Rouge to do my knee surgery. And the first thing he told me was the drill bit broke off, and if we took it out, it would cause you a lot more trauma than leaving it in. He didn't do anything wrong, but perhaps the drill bit was defective. I don't know.
If we can talk and try to be as focused as possible, the funding mechanism is that the first $100,000 physicians are self-insured, and after that
No, are insured.
are insured. I'm sorry, and the second tier of coverage, the $400,000 that the PCF supervises, is paid by physicians or by liability insurers.
No, by physicians. Physicians, hospitals, nurses, whoever the qualified provider is. You qualify by securing your underlying 100 and paying your surcharge for the next 400 plus medicals and judicial interest.
If you are the business manager for a physician, how does that cost break down? How much are they paying to the liability insurer for coverage, and how much are they paying to the PCF?
The numbers are just ballpark, but
That's what we need.
The first 100 usually costs 50% of the cost, and the next 400 cost another 50%. Next 400 plus,
Okay, so the liability insurers, half of the money paid by physicians for protection from medical liability claims is paid to the medical liability insurers for $100,000 of coverage, and then the second 50% is paid to the state PCF fund for the next $400,000 worth of coverage. Is that?
That's correct. That's ballpark. I mean, it may change by class, but that's the information I get from our surcharge payers, subscribers.
Now, is it not true that the standard medical liability policy that's sold to physicians in Louisiana typically provides $1 million worth of coverage?
Only if the claim is deemed not to be covered by the patient's compensation fund. It's usually what the language in those policies says.
Okay, so the medical liability policies often provide $1 million worth of coverage, which may or may not apply to a given case.
The policy says if the cap is not found to be applying in a situation, we will cover up to $1 million.
Okay. Have you all undertaken any analysis of how competitive the medical liability policies are that are purchased by our doctors every day in Louisiana?
No.
Have you undertaken any actuarial analysis of whether the doctors are protected or treated fairly in a system where they have to pay 50% of their premium dollar for $100,000 of protection? In other words, they have to pay 50% of their premium dollar for $100,000 protection, and whereas the second half of their premium dollar buys $400,000 of protection. Any analysis of that?
That's not really our purview. I mean, the underlying is the responsibility of the competitive market in that area. We think competition is a good thing, and competition is the best thing to drive rates down.
Do we have competition? And I understand that you're not an insurance executive, but I understand also that you've been working with the medical liability system in Louisiana for 12 years. So your perspective is going to be potentially helpful, at least to this member of this committee. I'll say that. I can't speak to it.
We're seeing several kinds of competition now at the underlying and at our level, by the way. There are groups of physicians that are choosing to opt out of the act, that have become not qualified. They won't receive the benefit of the cap. They won't receive the benefit of the panel, and their liability will be unlimited. That's a new phenomena. I'm thinking that if it catches on, it could cause us a big headache down the road. But I also think that they're taking a whole lot of risk. The other kind of competition, the most aggressive and functional competition is self-funding, self-insurance. Most all large hospitals self-insure or belong to a SIF, a self-insurance fund. Nursing homes the same way. They do not buy insurance on the marketplace for the underlying coverage. And analysis is done very often by those kinds of businesses to see whether or not it is more
In other words,
efficient.
self-insured versus buying liability.
Correct.
But my question, and I'd love your perspective if you have this information, how much competition is there in the liability insurance market in Louisiana for selling that first $100,000 worth of coverage?
There's,
10 or 15 companies?
there's over 20, but that are admitted to write.
Is there one or two companies that control 50, 60, 70% of the market?
Yeah, Lamico is the largest coverage
Okay.
of medical malpractice for physicians.
And they control how much of the market? Just and this is ballpark, I understand.
I have no idea.
It's right at about 50%.
Because we're here today and you all are saying, look, we've got to protect doctors from excessive medical liability coverage costs. And that's
We're not
a
changing
valid
the
point.
underlying, though. I mean,
I understand.
The
But I'm talking
underlying's
about the
good.
whole picture. And I think you all have some perspectives, again, that are helpful to this senator. My question is, how much profit are these medical liability insurers making in Louisiana? For example, they're paying $100 million worth of claims a year, and they're only taking in $102 million. They're just very thin margins, or are they paying out $200 million a year, and they're taking in $700 million a year? What do you all know about?
That's easily found out
Okay.
information. There are admitted carriers in Louisiana. Each admitted carrier has to file what we call a yellow book with the Department of Insurance, but I don't have that information.
Okay, so you're saying that the medical liability insurers in Louisiana are legally required to file a yellow book with Commissioner Donlin, the Commissioner of
The
Insurance?
domestic ones are.
Okay. Does that include Lamico or not? Yes. Okay. So Commissioner, at one of these hearings, it might be helpful to have Commissioner Donlin so he can tell us, are the medical liability insurers overcharging, or they're just barely scraping by, or, I mean, is it possible that they're charging, $300 to pay $75 worth of claims, that type of issue?
I can tell you only about experiences in another market, but basically, if you charge too much, you will lose market share. If you don't charge enough, you won't be able to cover your claims. So what they do is they generally issue back dividends to their members. Lamico is a mutual company, so any profits they have are owned by their policyholders. I think in the last several years they've been making substantial dividend payments to their policyholders, and that's how they keep the equal part of their business from getting out of hand, from charging more than they should.
Okay, so Lamico's paying substantial dividends. In other words, from an outsider would say that they're making good profits.
I think you need to talk to them. I'm really not.
Okay.
I can't represent them.
Okay, and again, that's just part of this equation about let's protect the doctor, let's protect the patient, yet let's protect the doctors from having excessive premiums that they have to pay. So you really can't tell us what percentage of Lamico's gross income is paid out in claims and what their net income or their profit margins are?
No.
Okay, and Mr. Schnauder, can you?
No, I
Enlighten us.
don't have that information.
Okay, have you ever looked at that data to know how much they make in a year in Louisiana?
No. But I think we're off topic. This bill has nothing to do with the underlying.
Well,
I mean, really.
but I think you said that we want to protect the doctors. In fact, I think Mr. Schnauder's comment was that we want to provide the best we can to the healthcare system. I think that was what Mr. Schnauder, did you say that? Did you make that comment, Mr. Schnauder?
Yes.
And I think part of my question is, do you perceive the mission of the Patient Compensation Fund, its primary mission is to take care of the healthcare system or to take care of victims of medical neglect?
When we're sworn in, we take an oath, and the oath says that we agree to represent no individual provider, that we promise to pay the claims of the fund and also to defend the fund. Now, those are two conflicting promises, so we have to make sure that we husband the money. We don't pay everything that's put in front of us, but by the time it gets to us, it's been well vetted. It's either been a judgment or a settlement, and we approve them all. And we are very proud of the care that we take for the future medicals of our patients, of our claimants. We cover lifetime benefits for those that need them due to the harm that is caused them by providers. And we do utilize the workers' comp fee schedule to come up with the cost of them. Sometimes they're not making everybody happy, but we have to have some basis to base our payments on. But those, there are some people who will settle that. Whenever I have a workers' comp claimant come to me and ask me whether they should settle or not, I always read them the law. If you settle the claim, you settled. That's the last shot you're going to have. And I try to make sure that all of my friends and clients understand what they're doing when they make a settlement. Sometimes if I were advising claimants, I would tell them perhaps maybe they shouldn't settle their medicals.
Now, and you said that you pay 99% of claims. Obviously, you mean 99% of the claims where there's a settlement for $100,000 or a judgment.
Right.
Because what...
Oh, more than 99%. I mean, it was 1 out of 3,000, I think, that we've actually gone to court on.
Right. But again, that's not 99% of all claims. That's
No.
99% of claims where either there's a settlement
Over
or a judgment.
100,000. Remember, we only see the claims over 100,000. I have no idea what goes on below that level.
And the next question is, okay, and do you have any idea of what percentage of med-mal claims are paid out of the total amount that are made with the Commissioner of Administration?
About 11 or 12%.
11 or 12%. Would you agree with me that in a case of a catastrophic injury under the current system, the bulk or the primary part of the burden isn't carried by the system, it's carried by the patient and their family? Say someone suffers a $3 million medical loss. And we'll just say a small part of it is actually medical bills. A lot of it is a dad gets killed because of medical negligence and the family's lost $2 million worth of income. Would you agree that under the current system, the biggest part of that loss is borne by the patient's family as opposed to the compensation system?
The system that we deal with is the system that is under the current law. We don't make judgments as to whether or not it's right or fair. It's just what the law is. We identify the claims. We use statistics to tell us what's being paid for those kinds of claims. If they go over 500,000 minus the medicals and the judicial interest, then we cover them, and that's part of the settlement. It's a negotiation, as you know. In every tort suit situation, there's a negotiation. Finally, if it goes over that amount, majority of those cases are medical cases, and those medicals are covered over and above the cap. And so
Is it Dr. Cossey or Mr. Cossey?
no, it's Lawyer Cossey.
Lawyer Cossey.
But it's
But
Cossey.
to get back to
It's
the
Cossey.
specific-
People in Shreveport are Cosseys. I wish I were related. They have money.
Well, I'm going to pronounce it the way you want me to. Cossey?
Cossey.
Mr. Cossey, again, the question is, if a dad dies due to medical negligence and his family loses $2 million worth of income, would you agree that the patient's family carries more of the burden than the patient compensation system?
That's one of the trade-offs that has been presented by the system. I don't defend that. And in fact, I think that group is taken care of to a lesser degree than the brain damaged child who doesn't settle their medicals. We will cover their medicals forever, but if that dad is dead and his income was a lot, $2 million a year, and we don't have many of those, by the way. Most of our claimants are non-earners. Most of them are either on disability or non-employed, because we have a lot of nursing home situations and people who are retired. But we have occasion of employed persons that go over the cap, and they do have a loss.
Okay, and I think my concise question was, in instances where a primary wage earner for the family dies due to medical neglect, in those cases it's the patient's family rather than the compensation system that bears the bulk of the burden. Is that true?
If it's over 500,000, yes.
Okay. And you made a reference to, look, we may have a doctor situation where we see lots of claims, and then we may talk to them about how much they have to pay into the system. I remember an instance years ago where I had a patient that was blinded by medical neglect of someone who was doing, I don't know that names is pertinent to what we're doing, but an eye surgeon that was doing almost assembly line eye surgery. And when I called the PCF to find out what information they had on this particular physician, they gave the statement to me, well, when I pull up his name on the computer, it, quote, lights up like a Christmas tree, unquote. And this is my question, and I said all that to say this. Is it true that if a physician has multiple complaints, even multiple sustained complaints, that information is not public information, is it?
No, it's not.
Okay. So the public doesn't necessarily know if there's a physician who's had multiple instances of neglect or injury, and they've been reported and claims have been filed. You all are not going to consider that public information, are you?
No, we're not. And once again, we're not a licensure body. That is the purview of the Louisiana Board of Medical Examiners. We're covering the claims over 500,000. We don't just make decisions based upon anything other than the losses that a physician incurs to the patient's compensation fund, and then if it goes over his payments in, then he has to make an additional payment. But whether that physician is a good physician or not, or qualified to practice medicine, is a decision made at the Board of Medical Examiners. We don't have that expertise.
Thank you, Mr. Kase. Mr. Schneider. Thank you, Mr. Chairman.
Senator Luna for a question.
Gentlemen, we know that our cap in this state is $500,000. How does that compare to other states? How many states have caps that low or lower?
Well, I'll just take a stab at it. If you've seen a cap, you've seen a cap. They're different in each state.
That's my question.
Well, I'm gonna answer your questions as best I can.
Okay, sir. Well, hang on a second. Let me interrupt you, please. My question is real pointed. How many states have a cap of $500,000 or lower?
Well, the caps in other states are different from Louisiana's cap, was the point I was trying to make. Mississippi's cap is below $500,000, but it's only on non-economic damages. So in that regard, it's different, and it doesn't cover the economic damages that Mr. Senator Milkovich was addressing. Ours does. There's a difference.
We got Mississippi at
and
lower.
Texas has a similar cap, and it's below 500,000. It's 500 or below, and it's once again on non-economic damages, and it moves depending on what kind of provider you are and whether you're public or private. Texas has a different system. All of the states have different systems. They're not apples and apples.
Are there more, if we're oranges, are there more apples and oranges?
I can't tell you that.
Well, I mean, do we have anybody that our system is similar to?
Well, we were most similar to Indiana when we started. We were identical. But we have diverged from the Indiana path in many regards. For example, they pay.
Anybody else other than Indiana that we're similar to?
Not really. We're pretty unique. There's only about 13 states that have funds such as us, and there's only about 9 of those that are viable. Many of them pay, once claims exceed, only on catastrophic injuries, they only pay once a claim is at $1 million or above. There's not a lot of states that are anywhere close to similar to us. No one pays future medical bills like we do. You know, there's been comments that the cap has never been increased since 1975. Well, that's not true. In 1984, the Supreme Court ruled that it was $500,000 plus all medical bills from the date of the injury. And that's a huge increase to the cap. All other systems don't have future medicals. They may pay $1 million.
When was that
but that
case?
includes medicals.
When was that decision?
84.
1984.
So there's not been any increase since 1984?
Correct.
Instead of 1974?
That's correct.
Okay. The question where y'all talked about the percentage of cases that you pay being 99%, where there is are we talking about where there's a unanimous panel?
No, that's a different issue.
Okay, because y'all don't necessarily, you go try cases sometimes with unanimous panels, don't you?
And the majority of cases tried are tried by the healthcare provider and their underlying coverage. PCF, we don't try 5 cases a year, less than 5 cases a year, on average. Sometimes we don't try any in a year.
Okay, that's just the nature of you're not an insurance company.
Right.
Correct.
You're a claims paying service.
That's what we are. That's
Okay.
correct.
You know, and one of the things you talked about earlier, Mr. Snyder, because you and I knew each other from a previous life, LIGA, which is also a claims-paying organization. One of the things you talked about was the rates and the increase that was potential here. You know, we'd compared earlier automobile insurance rates in Louisiana and that kind of thing. Well, automobile insurance rates are based on what kind of car you drive and where you live and who drives it and all those kind of things. But at the PCF, when you're talking about increasing rates at 4.5% per enrollee, you're increasing the rates on a family practitioner just like you are on an orthopedic surgeon or a neurosurgeon.
Of course, the base is a lot lower.
Okay, well, let's answer my questions first, and then you can make your comments. Am I correct in that?
That's
You raise it across the board, don't you?
But if you use your analogy, if an insurance company came in and they had to raise everybody's auto insurance to a new level, it would be a flat amount across the board as well.
But that's not the way that works. The point I'm trying to make is you're comparing apples and oranges yourself. The real situation here is that the reason there's a 4.5% increase per enrollee is not, it's more related to the overall cost. It's not related to the exposure.
Correct.
So why can't we look at it to where we make it relate to the exposure? This bill is a very narrow group of doctors. I can't fathom how a dentist could fall into this category of this bill. You mentioned a dentist earlier, but I can't. I mean, unless he decided,
Anesthesia.
you know, maybe if they decided to do some kind of oral surgery that somehow they involve the brain in or the brain stem or something like that. But I mean, it would be the most extreme case I could imagine. I don't know how most of these physicians would fall into this category. I think this is an extremely small group of physicians we're talking about. Why, if the cost goes up, and these are very specialized doctors that make typically much more money than these other doctors, why would they not have to bear the cost of that if it were to come to fruition?
Well, the way, talking with the actuary, actuaries use statistical data and credible data over a long period of time. We don't have that data because we don't have this in place. His reasoning is we would have to put it across the board until such time, and he usually wants 8 years minimum, he likes 10, in order to then look back at the history to say, okay, you had 100 brain damage child cases, these were the specialties of doctor, hospital, whatever, that caused them, so this is what their rates need to be.
Why can't we use empirical data from other states?
We do.
He uses that, but again, we're so much different. The hard part an actuary has with our system is the unlimited medical bills. We're still paying medical claims on a 1977 case. Well, when that physician enrolled in the fund, they paid an amount to 500,000 limit, period, the end. Well, in 1984, Supreme Court said, no, retroactively, you're going to pay all the medical bills. So that 1977 case all of a sudden became an exposure to us that we're still paying. Okay, so,
Still paying from 1984, from the case that was decided in 1984? Is that what you're saying?
oh yes,
Okay. You're not talking about that specific case. You're talking about currently what it is.
currently.
So
yeah,
what you couched as the increase in 1984, we're still currently paying that.
correct.
Okay. I understand that. I don't know what that has to do with this bill, but clearly we would
Well,
still
my
be
point
bound by
is-
the cases
My point
that are
is, the
there.
actuary can't, he has no guesswork. Usually, on any insurance, you have a policy limit. So the actuary can say, okay, worst case scenario, this is what it's gonna cost you.
And I understand
With
that, but
the
isn't that the-
compensation fund, he can't give you that number because it's unlimited.
Okay, but doesn't the same scenario apply in a lot of other states and a lot of other instances, or, like we talked about workers' comp earlier? It clearly applies in workers' comp.
But they have policy limits. We don't have a policy limit because we're not an insurance company with a policy. We pay unlimited future medicals. No matter what the law is, workers' comp, you pay medical bills till the person dies. But that's through an insurance policy that has a limit. So the actuary can say, that's what that limit costs.
Are you telling me that maybe we need to switch to an insurance system in Louisiana instead of having a PCF, so we can figure out what's the best practical way to do this?
That's your decision. We will be here as long as you want us.
But you limit the.
Well, I mean, is that a better
huge,
system?
That unlimited medical bills for patients such as Kai is precious. It is, nowhere else in the country has that. So we are taking care of those injured claimants until they die.
Mr. Snyder, I'm not going to challenge you on that per se, but I'm telling you, I'm almost certain that there are other states that provide lifetime medicals for people that have been malpracticed on. Are you telling me I'm wrong with that?
I've never seen one.
Okay,
I'm not going to tell you you're wrong, but I've never seen one.
One of the other interesting things that you stated earlier when you were talking about most of your claimants with the PCF, and you said most of them were non-earners. Has anybody ever looked to see if that's any kind of correlation with a level of competent care that they receive, that poor people that don't have insurance and they get lesser doctors, they don't receive good care? Have we ever looked at anything like that?
We don't have any information on that. Oh, we do check when we analyze a claim as to whether someone's employed or whether they're not, and that's just that changes the whole negotiation as to what the future damages will be, because you're including income then.
I think it has to do with age more than anything. We
Yeah.
run statistics on the age of the claimants, and a large portion of them are 5 years and under, and a very large portion are 60 years and older. Because they have health problems, and you have the bad births and injuries at younger ages, sicknesses, illnesses, that.
Those are the ranges of ages where you need more health care.
Correct.
Okay.
So the potential for malpractice is greater.
Well, I think one of the things that we do incorrectly here in Louisiana is that we have no accountability for good doctors versus bad doctors, because we have doctors here who repeatedly commit malpractice, and we have doctors here who never commit malpractice. And until we address those issues and we look at these hard questions, I don't think we're ever going to solve this problem. Thank you, Mr. Chairman.
I just have a couple questions myself. A few minutes ago, and y'all may not be able to answer this, but it was discussed that Lamco sells $1 million policies whenever the doctor's only going to be on the hook for $100,000. Why would that be? Why would that be necessary?
Well, there were many years when there were active court cases that challenging the constitutionality of the cap, and they sold that policy as an additional opportunity of coverage for that doctor in case that case was lost and the cap was found to be unconstitutional.
And let's see, I had one other note. We talked about healthcare cost and how this could potentially change that. What percentage of healthcare cost is associated with attorneys' fees and premiums and things like that? Any idea on that?
It's in the single digits, small single digits, as far as the overall cost of healthcare.
All right, I think Senator Milkovich has one final question before we move on to the opposition.
I'll wait.
You wait? Okay. The board's clear. We
Thank
don't
you
have
for
any
the
more questions
opportunity
for you.
to come before you today. We look forward to working with you on mal issues.
We do have quite a few cards in opposition, although we only have one wishes to speak. Ms. Jennifer Murzak, we spoke about that the other day. I think I got it right. If you'd come to the table, and then while you're making your way down, I'm going to go ahead and read through those that are here in opposition but wish not to speak. Jeff Williams, Louisiana State Medical Society. Sabrina Noah, Louisiana State Medical Society. Wes Hadaway, Louisiana State Medical Society. Ms. Dinkler with Children's. Ryan Haney, Lamco. Chris Kohler, Adams and Reese. Stephen Guillory, Baton Rouge Area Chamber. Joe Donchis, LNHA. Dan Robin, Jim Harris, Coalition for Common Sense. Lemony Walker, Louisiana Nursing Home Association. Berkeley Durbin, Medicine, Louisiana. Greg Waddell, Louisiana Hospital Association. Mark Berger, Jennifer McMahon, Louisiana Hospital Association. Greg Cossin, Louisiana Chapter American Academy of Pediatrics. Ronnie Duncan, FMOL Health System. Eddie Lowe, Louisiana Chapter ACOG. Cindy Bishop. All right.
Mr. Chairman, members, Jennifer Marusak on behalf of the Louisiana State Medical Society. And let me start off by assuring you that this is the last place I want to be sitting right now. Secondly, I don't know if Senator Gaddy, where he went, but I want to assure him and Mrs. Gaddy that I and our team, which I know Senator Gaddy met a couple of weeks ago, purposely made the decision to not ask our members to contact he and his office. So we did not do that. We were not the ones contacting his office. We have known from the beginning that he got elected of his family situation and knew that this type of legislation would be coming from Senator Gaddy, and we understood that it would be coming because of his understanding of the situation. And so we respect him for bringing that and understand it while we still disagree with it. We understand it's not a perfect situation, and necessarily not a perfect system that we have. But yes, Senator Luna, we are the only state that pays all future medical costs, and so it does kind of muddy the waters when you're comparing apples to oranges to grapes, actually. And when we talk about not only the possible or the not possible, but the actual premium increases that would be coming, you know, you have to look at what else all of our providers, and not just the physicians, but the hospitals, the nurses, what's come to them in the last couple of years that's actually forced some of our providers and physicians in particular into early retirement, whether it's been the constant technology upgrades and investments that they've been forced into, the additional personnel investments because of the red tape that they've been forced into with Bayou Health, if they want to continue caring for the poorest of the poor in Bayou Health. the ICD investments and mandates through the Affordable Care Act, the medication expansion cost for those especially in private practice that are coming July 1st that we know, the tightrope that's already being walked through the private public partnerships for the state and the LSU system and our medical schools. Those premium increases, we just know for the providers and the facilities involved would be detrimental to the healthcare system in our state. Because when we look at all those providers that we're asking to participate and continue to participate and actually grow to participate in Bayou Health and with the expansion of Medicaid, we're already having problems getting OBs to participate. I had some of my pediatricians call with concerns about simply treating children for concussions, that they're worried about their liability and how that would grow with this legislation. Of course, never mind to say the pediatric neurosurgeons that they would have the ultimate liability. But again, we just would like to voice our opposition to the legislation for the obvious reasons.
Senator Milkovich has a question.
Thank you, Mr. Chairman. And is it Jennifer Marzak?
Marusak.
Marusak.
Yes, sir.
And Senator Luno is helping me with the spelling.
He sees
And
it
I
every
think
day.
Chairman Ward got it perfect the first time. He's a great chairman. He does a great job, doesn't
We
he?
practiced the other day together.
Okay.
This side.
He's very gracious to all sides, and we really appreciate his work so much. I'm going to very quickly reiterate, because this is a gut check day for us in this committee, what the Gaddy family's been through, and really the light that their plight has shown, not just on what other families go through, but also on the system. And I thank you for what you bring to the table, because you're saying something very important for everyone in this room to hear, and really the state. Our doctors are not really the bad guys. The doctors nowadays, they're dealing with like you said, the Affordable Care Act, electronic records. That's a joy for some of them. The ICD code, that diagnostic code that's gone to 9,000 definitions, gone crazy. Their staff costs are going up. Some of them, I've heard over the last year, sometimes they don't get the respect that they deserve from the Louisiana State Medical Board. You don't have to say anything about that, but you know what I'm talking about. And on top of it all, ERISA, the federal law, used to be under state law that if there was a medical bill that was owed, you go to state court, go in front of the district judge, bang the gavel, 60 days, pay the medical bill, and pay the doctor's lawyer for having to come here. But now we have ERISA, which is a federal maze, and doctors sometimes have to have as big a staff trying to get medical bills paid as taking care of patients. And if I'm wrong on any of it, correct me.
No,
Our doctors are doing a heroic job fighting the bureaucracy, aren't they?
we're trying to.
They're trying to. And they are. And they're still, and I think I'll let the other members of this committee correct me if I'm wrong, but I believe it's the sense of this committee that our doctors are doing a heroic job. It's certainly the belief of this senator. But let me ask you this, because I'm curious about the extent to which the system, including the liability system, and we have dedicated professionals in the medical liability system, we have dedicated professionals with the PCF, but sometimes it seems like the system is pitting the patients versus the doctors when really they're on the same side. Do you agree with that?
Absolutely. I mean, the doctors are there for their patients. That's the whole reason they get into this profession.
I got it. But let me say this, and this may not get answered, and we're going to have to be really quick because we've got other things. But you may think about this, you may be able to respond to it. Maybe we'll have a conversation in the hallway at some point in the future. But maybe how much profit is the medical liability industry making in Louisiana? In other words, are they making $20 million a year profit in Louisiana, $100 million?
I would have absolutely
Scores of
no
millions?
idea. More than me.
More than you, because do you agree with me that if the medical liability industry is making excessive profits, that means the doctors are being forced to pay excessive premiums? Would you agree with that?
I have no idea.
And if you can research that or find something out and bring that to this committee, that'd be great. And the other thing, very quickly, is do you have any idea, under the current system, how much the liability insurers pay to hire insurance defense counsel versus how much they pay to take care of patients? Do you have any idea of that breakdown?
And I don't have that information as well.
And I'll just ask you to keep an open mind to trying to find that information and sharing it with the members of this panel as we go
So
forward.
they have their own board. Limico and those companies have their own boards that I'm sure you could get to come speak to you when you request them to.
Okay. Thank you, ma'am. Thank you, Mr. Chairman.
Thank you, Senator.
Senator Luno has a question for you.
I appreciate you providing the information because I'm telling you, I thought there were other states that did it the way we did. But all the rest of the states, you just have to come in and prove up what your future damages are, and they're awarded to you.
With their caps.
Yeah. Now, how many states have caps on the future medical care?
I don't know. But they would have, from what I understand, they would have their caps like your Blue Cross, policy.
It's my appreciation that I'm not aware of any other state that has a cap on future medical care. It is what it is, and you get it. You just get it up front instead of having it paid out like we do.
Well, but that's a guessing game then, right?
Well, then that's my point. Maybe
On
that's
what your
something else
future medical care would be.
Maybe that's something else we should look at
In
getting
other
away
states.
from, and actually looking at awarding those future damages instead of, if we can't determine what it is to set proper rates to charge doctors correctly, maybe we ought to look at changing that. So that's something for you guys to consider. Thank you.
Sure. Thank you, Senator.
All right, I think I have one question. I think we'll be done. Senator Milkovich just touched on this. Have premiums been raised since 1974? Have they gone up for doctors?
I don't know,
You have no
Senator.
idea?
I don't know. I don't have to pay them, so I don't.
Okay.
I'm not aware.
All right. Well, I think that's it. The board's clear now.
Thank you, members.
Senator Gaddy, you want to close? Oh, one second. We do need to, and I believe you and Senator Martini got together on the amendments you had, and he proposed to where it says on Amendment 4 and in Amendment 5, catastrophic brain injury means any moderate or severe traumatic injury. We would add means any moderate or severe
Brain injury.
traumatic
Yeah.
brain injury.
And we believe that there might be somebody who says, oh, it's just traumatic injury. But we wanted to make sure everywhere that moderate or severe traumatic injury was in the definition, that brain was the organ that we were talking about, because we didn't want this to get outlandish in its scope. And I have no objection to those amendments. The staff and I worked on it.
We'll withdraw the first set of amendments and resubmit them with traumatic brain injury.
Thank you.
And I don't see any objections, so those amendments stand adopted. You can close.
Well, I just want to say, first of all, I want to thank Kai's family for coming. A lot of people could not make it because when you have a severe brain injured child who meets this narrow criteria, you don't leave the house much. So when he hears it's ready to drive, I'm sure he loves to get out of the house. And it's been nice to get to know his family. I did not know they were coming until about a day ago. And so if we could just thank them for being here. And I just want to do that. And your words were so eloquent. I know that you were limited in what you could talk about, but every word you said hit my heart deeply, and I appreciate you for coming. Kai, I appreciate your hard work and learning to walk too, man. That's a big deal. That is huge, and we're very proud of you. And if I happen to get to heaven and run into each other, introduce yourself to me. Remind me of this day so we can talk about this day, okay? We appreciate y'all so much. And Big Sister, wow, What an angel sent by God to work with your brother. And I can see your compassion and how you helped him out of here to go to the restroom so Mom could keep talking. And what a blessing y'all are to come down here and testify and walk up all these steps and go all these nooks and crannies to find this room. And we appreciate you for being here. You know, my crystal ball is broken on a lot of the things that we talked about today. Insurance rates, ups or downs, I don't know that. I mean, I think we've done a lot of insurance reform since I was a baby that I've had to read when I was in law school, and none of it really reduced rates. There was promises of rate reductions, but, you know, businesses don't see it, people don't see it. And I want to give you just, I appreciate the unlimited medical payments under our current system, but if you can imagine to a family that's been through it, that's kind of a slap in the face, just in this small reaction, because the lawyer has to explain to you that the hospital that hurt your child has unlimited resources to help pay for the medical care needed for the mistake they made. Unlimited. But you're limited to $500,000. So the reason that was put into the law is it was lobbied for and agreed with by the lobbyist for the healthcare industry, because they said this is kind of great because everybody pays into a fund that pays our doctors to fix the kids that are hurt. But we still want to keep the cap there. I'll tell you, Indiana wasn't a cut and paste. They've raised their cap to $1.25 million across the board, not just for catastrophic brain injuries. They're at $1.25 million. Indiana, I mean, I think that's where Notre Dame is. I mean, God, those guys figured it out before we did, you know. And I don't see people struggling with that number in Indiana. But I will tell you this, my crystal ball is broken, like most of us have. It's just real broken when it comes to extrapolating or deriving underwriting behavior of insurance companies when this anomaly is placed on their desk. We do know it's probably going to go up. Because even if all the marginal practitioners left because they couldn't afford a higher policy, they would still find a way. And we heard testimony of this earlier. They're making doctors buy $1 million policy, and the Supreme Court has said the cap is constitutional. Now think about that. Senator Ward, if you were a doctor, I'm going to sell you $1 million policy, but the most per claim that you would ever have to pay is $100,000. Imagine that. And they want to tell me that I'm here advocating for my child and children like her, and that's going to raise rates. Well, heck, what's raised the rates is that you make somebody buy $1 million policy when they only need $100,000 in coverage. I mean, I have to take off my shoes and socks to count to 20, but even I can figure that out. If you make somebody buy $1 million in coverage when their worst case scenario is $100,000 per claim, that premium's going to be a little more for that $1 million policy than it is for the $100,000. Crystal ball's broken on that, but I do know this. $5 million for a family going through this might allow mom to stay at home and not go bankrupt, like we heard today. $5 million, I can't find anyone that would say a child's brain is worth less than that. Even when you ask the bean counters, they say a child's brain, if taken, and the pain and suffering and what they contribute to society, not even counting their loss of earnings, because you can't really calculate that with a child with an economist. Nobody says it's worth less than that. A lot of people say it's worth more than that. So I would ask that this committee allow this bill to be heard on the full Senate floor. Because I will tell you this, Kai doesn't have a voice. Becca doesn't have a voice. Our first prayer, our first Bible study that we did was what? Lord, please help us be a voice for the voiceless. So we have several people that are voiceless on this issue, and we have some people that have not lacked the voice. When we talk about freedom of speech, it's an important thing, Senator Milkovich, very important. You know that. Rebecca can't talk. You know, Kai struggles. He'd love to come to this table, I'm sure, and talk about how he learned to walk from his brother and all that, but the speech portion of his brain doesn't work that good. A lot of people can't come here and talk today because after they went through this process and settled their case for less than $500,000, there was a gag order written into their settlement. So they can't come here because they're scared to death they'll get sued for civil damages for telling the story. But there's a group here whose freedom of speech has not been impeded. And they speak with money, and they speak in groups. Their freedom of speech has not been impeded at all. So we just have to decide who's the voice of the voiceless. And once we decide that, this becomes an easy bill to talk about. So I thank you for your time. I appreciate you giving me this day. I appreciate your kindness to my wife and my daughter. I appreciate your kindness to the people that came to speak, and I look forward to answering any questions that you have any more. Thank you very much.
We'll go off of what the pleasure of the committee is. There is a motion to move favorable by Senator Luno as amended. Is there any objection to that? Seeing no objection, the bill is moved favorably as amended.
Thank you. And I will have the data on the Senate floor of the questions you had. I will bring that data together so that the committee can make a full decision on that. Thank you.